Hello everyone, my name is Vsevolod Volkov and I am a partner at EVERLEGAL. Today we start the series of legal talks in which we will cover important issues connected with the legal environment in Ukraine and how it develops. We will cover such industries as energy, agriculture, pharmaceuticals and a lot of others. The first topic that we will start with is current development in connection with proposed changes to Ukrainian regulatory issues with renewable energy. The renewables energy sector has started to develop in Ukraine decades ago, and by now the increase of volumes of production from renewable sources has increased dramatically. The Ukrainian government now believes that it's no longer capable to provide green tariff benefits in the way they were structured decades ago. Many investors are dissatisfied with what the government suggests today. About a month ago, the government has signed the memorandum with the green energy sector about how the reform shall go. Those memorandum on behalf of the renewable sector was signed by associations. None of the investors has decided to join this memorandum, which gives a hint that no investors are actually satisfied with what is offered by the government. And a lot of investors consider different ways of protection. It's important to know here that you can get protection based on different things: it's national law and international treaties. International treaties is something that most used by international investors from different countries, depending on how the treaty is structured. What we have today is bilateral investment treaties between Ukraine and a couple of countries, and the Energy Charter Treaty is the most frequently used in order to get protection for energy investors. Basically, both bilateral treaties and Energy Charter Treaty provide protection for expropriation, discriminatory treatment, and for so-called fair and equitable treatment of the investors. It's important to know here that the majority of claims of investors for the change in green tariff regime are based on fair and equitable treatment, or sometimes it is also characterized as reasonable expectations that the investor gets. The things are not as straightforward as many investors today publicize in press and media. International investment law gives and recognizes the right of the states to regulate the energy sector. For such countries as Ukraine and many other developing countries, there is also a presumption that those countries may change their regulatory regime, especially in the times of crisis. The matter is whether those changes which the government propose or implement actually protects in a proper way and treats properly investors based on what they could reasonably have expected. In majority of cases, there are a lot of circumstances with which the tribunal will take into account to determine whether the investor's rights will be breached or not. And it's important or advisable for the investor to check the latest jurisprudence by EXIT or other tribunals about how they evaluated and estimated the different arguments brought by investors depending on the text of the regulatory statutes by the states, how the changes were implemented and what the dialogue with the investors was. After the Ukrainian government announced its plans to change the green tariff regime, a lot of investors started to look into how they could change their investment protection or available treaties. It's worth noting that investment law often treats so-called treaty shopping as the abuse of rights by the investors. Whether there is a treaty shopping or not will be determined based on when the investor learned about changes in regulatory regime. Any change that the investor plans after the respective changes have been announced by the government or implemented will give grounds for the tribunal to refuse in providing investment protection to the investor for the abuse of his rights. What can be clear from what I have just discussed is that the claims of the investors against the state will much depend on the circumstances about how regulatory regime was structured at the beginning and how the government behaved itself when it was suggesting changes. Therefore, when you plan potential dispute with the state in arbitration or in other proceedings, it's often important to start with the feasibility study of what could be claimed, what circumstances could be relied on, and what damage could reasonably expect to get from the tribunal. We can help you with that.